doing social service at Dayalbagh. He entered the Bar Association of Kakinada in December 1980 and soon joined the Bar Association. He has commanding good practice and he conducted number of cases successfully in East Godavari district, basing his concentration place at Kakinada. His wife, Srimati Usha Kiran, is also an advocate who hailed from Visakhapatnam Bar Association and later joined Kakinada. The marriage in between the Nageswara and Usha Kiran took place in 1987. Both of them practiced in Kakinada till they switched off their visas to Dayalbagh, Agra, Uttar Pradesh, which their religious headquarters of Radha Swami Satsang, to which they are affiliated. They are serving their institution there. See, Nageswara is serving the institution as law officer there at Dayalbagh, and that both of them are still continuing the affiliation to Kakinada Bar Association with the practice online. He started the career from his brother's office, Sri Enamanda Subbarao Garu, in 1990, and later he put up independent practice and he trained number of juniors who are also having good command on law. He has been standing counsel for the State Bank of India and various other institutions, and he has a command on the subject in this matter. You are all aware that now the important subject for today is elementary principles of the Transfer of Property Act. Number of us will know about the mortgages, sale, leases, etc. But whereas our advocate fraternity does not know about what is the vested interest, what is the contingent interest, or when the contingent interest will come into the vested interest, whether any alienation, prohibition of permanent alienations, etc. are valid or not. And all these things are command from section 1 to 52 of the Transfer of Property Act. Even I can say, even after this practice, I have to learn from him because such a thing is a very important aspect in this matter. So I request all of you to hear patiently Enamanda Nageswara, who is also having command on the Transfer of Property Act and who will enlighten us with regard to the subject on this aspect. Thank you, one and all.
Thank you, sir. Thank you, sir. Thank you very much, sir. Sir, YNR, please, sir.
Audibility bondandi?
Yes, sir. Yes.
Audibility, video, clarity of some checks.
Everything fine, sir. Everything fine.
A difference in the major of indication.
Okay.
Respected friends of the evening, moderators, and the organizers of the institution, organizers of the meeting, and more particularly, my senior friend, Sri B. Gopal Krishna, who is having more affection towards me and who gave a flattering introduction towards me. But I am afraid whether I can maintain the expectation of Sri BGK during his few words at the end. Thank you very much. Before going to the subject, at the outset, I also very much thankful today to got this opportunity to mingle with some of my past colleagues and friends with whom major part of my life I have spent. Now coming to the subject. As a matter of fact, law of property means, I think today so many of my friends have expected, or with reference to the treatment of subject I am saying. So without too much of harangue, the moderators told me that our junior friends who are prospective towards the selection of their district councils or the district judges and who are more young friends So regard having two particular sections of the property, I have prepared myself to make a short endeavor. Regard having only the interest of junior friends and those who are going to the examination. And therefore, I felt that it is not ideal for me to go through each and every section and make an interpretation or the explanation to the section. That's why when I am requested to make an address, I said to our friends that I will touch the introduction of fundamental concepts so that our friends will enrich and the subject will be developed. So the treatment of subject today, what I want to use not by section wise. My friend, all my friends may make it a point. And my appeal to all the seniors is that they may not feel pale of the way in which today I am submitting. And all my young friends may make every endeavor to pursue the concept of law before going through the sections of Transfer of Property Act. Because basically the Transfer of Property Act did not define or did not create any interest in the subject matter of property. That is the fundamental thing. The Transfer of Property Act only is intended to regulate the transfers or the conveyance of the property. At the time of passing of the Transfer of Property Act, there were a number of systems which were in vogue at the time were not now in vogue. That is the basic thing which my young friends have to bear in mind. Because there are also some obsolete concepts and there are also some obsolete topics which remain in the textbooks of Transfer of Property Act. And rarest among the rare cases we may come across, either remain after several years from the apex court, or if we happen to come across with the old documents wherein certain the rights which have been created very, very long back prior to the independence. So the phrases and the words and the concept and the system of administration with reference to the property and also the administration of the villages at those times are to be bear in mind before going to read the sections of the Transfer of Property Act. That's why I contemplated that before that I want to give, though not going too much far off the ancient concept, but from old concept to the present system with reference to the matured system in which how the properties are being dealt with. So coming with the concept of ownership, just let us start very briefly. I don't go very much deep into the subject. Concept of ownership can be termed broadly in two aspects. Two aspects in the means, one is the original occupancy, and the second is the acquisition of property by derivative interest. These are the two broader concepts you have to take in mind. So if we go to the ancient point of time, there was no system of documents and there was no system of occupancies because the society has come forward. The advancement of the society has come forward. In the early days, there is no concept of owning the properties. After advancement or after growth, after transformation from the nomadic life to the settled life, those who occupied the properties began exercising possessively as if that they are the owners of the property without knowing the concept of ownership at that time. That means possessively means because they are preventing the some others because we have occupied this property, unless with my permission you can't make use of my property or you can't take my property. That is the original concept. So how this concept of ownership has been transformed in the hands of jurists, how they have been explained. Just to the present matured system of concept of property, we will refer only Austinian definition of property. property term has been used as a synonymous to the ownership. Likewise, ownership is the metonymy of the property. Austin says three elements are necessary to say one particular individual is the owner of a property. It is his power to exercise against a determinate thing, and that power to exercise against the determinate thing is indefinite in point of use, unrestricted in point of disposition, and unlimited in point of duration. These three elements are still recognized. That is the only basic elements of the property, because there is no other option, there is no other thing also to incorporate anymore, to add or supplement. So unrestricted in point of user means, or indefinite in point of user means, the owner of the property can use his own property in any manner as he likes. He can put the property in any way, and except save from the offense of arson, he can destroy the property also. That is the right of ownership which was exercised. And the other element which the Austin emphasizes is that it is unrestricted in point of disposition. This is more important, because unrestricted in point of disposition means when once we are exercising the ownership of the property, the plenary right of ownership. The plenary right means right to enjoy the property, right to alienate the property, right to destroy the property, and the property shall pass on in succession, and the property shall be capable of being seized by his creditors on the event of it being charged for any debt made by the owner. These are the elements which we call that unrestricted in point of disposition. Whether as a whole he can dispose of the property, or whether he can split up, and the individual interest from one property can be disposed of. That is a later development, and which has been recognized, and which also is having statutory recognition with reference to it. When once we combine all these things, we call it the whole interest in the property, or it is a plenary right of ownership which can be as a whole transferred from one person to another person. And the other element which the Austin emphasizes is that the property shall be unlimited in point of time. Unlimited in point of time means, in the matured system of jurisprudence, there are exceptions after the regime of Austin. But at that time, a property shall be capable of being enjoyed throughout the life. As long as the ownership continues, the property continues. As long as the right to hold the property continues, as long as the individual who owns the property is alive, the right to property also continues. But this right is attached and runs with the property, and it never dies along with the person. So that we call that the property can be passed on to the legal representatives or passed on to its successors in interest after his demise. That is a continuity. That is a continuity, and that is otherwise called as intestacy on succession. That is also one of the elements of absolute ownership. As far as the dispositive capacity is concerned, during the lifetime, a person can dispose of the property either by inter vivos. Inter vivos means a transfer between two living individuals. And ab testamento means a transfer of property or the disposition, though we cannot strictly call it the transfer, it is the disposition of property, which will be given effect to after the lifetime of the disposer. These are the elements of ownership which have been confined. This is one thing. Minding all these things and accepting this concept of definition, gradually the concept of ownership has been developed into, when it is a plenary right exists in one particular individual, it is called the absolute ownership. A particular individual is having an interest along with some other person, it is called the co-ownership. That's how the ownership has been absolute ownership, co-ownership, conditional ownership, and likewise. And there are other kinds of ownership which are called the estate restricted to the personal interest or personal enjoyment of the individual to whom it has been granted. These are the concepts of ownership which were passing at the time of Transfer of Property Act. What are the interests which are restricted to the personal enjoyment? Nowadays, directed from present time to back, if we go, the known example to all of us is a transfer of an interest under Act 9 of 77 by the government. Assignment of the land which has been made by the government. And likewise, a land which has been granted under a deferred patta. These are the interests which are inalienable or which are not transferable and which are only to be enjoyed during the lifetime of the grantor. Earlier, before passing of the Transfer of Property Act or by the time of passing of Transfer of Property Act, the Board of Revenue used to govern all these rights. And there were ENOMs for which subsequently there was a legislation as till the ENOMs Abolition Act, ENOMs were there, different kinds of ENOMs. ENOM means it is a grant of property which has been made by the government on the reduced rent or without any rent or favorable rent. These ENOMs are intended only to those persons who rendered service in the administration of the government. They are not the salaried employees. They are called in those days as village services. Village services means village karanam, village munsip, village servants, that means watchmen of the village, who are holding paharas during nights, who are carrying the works which have been contemplated, who are collecting the land revenues from the rights. Likewise, the carpenters, goldsmiths, blacksmiths, and these are all the village artisans who are having there. And for all these people, the government or the jamindars in those days, that is also another concept, just so we will briefly deal later. These grants were made to those persons who were rendering service to the village. They can enjoy the property which has been granted by the government without any absolute interest in the property, but they can continue in possession of the property and they can enjoy the property as long as they render service to the village. Rendering service is nothing but the consideration. That's why it has been granted. Suppose if a carpenter is there during his tenure, he renders the carpentry service to the entire villages wherever his requirement is there and called for, and he enjoys the land which has been given as a service ENOM. After him, his son or somebody else in his family who are eligible and who continue the service, they will enjoy. Otherwise, the property will again resume back to the government or the grantor, whoever the grantor. Another kind of restricted estate is the landholders. Landholders means the jamindars. Jamindars were the middlemen or the intermediaries between the rights and the government. They were given certain lands, but unless after the jamindari abolition has been passed and the rights have been recognized as the rights of patta and personal grants of gain, the property always restricted to their personal enjoyment only. These aspects we simply refer in section 6 of the Transfer of Property Act, but there is no definition at all in this. For that purpose, if with these concepts we bear in mind, it is easy for us to understand what incident can be transferred and what incidents cannot be transferred. Because section 6 of the Transfer of Property Act simply says that these are the interests which cannot be transferred at all. So this is the basic concepts at the time of passing of the Transfer of Property Act.
Sorry for the interruption, sir. Gurugaru, మీ పక్కనే డిస్టర్బెన్స్ వస్తుంది సార్. బహుశా మైక్ కానీ ఏదైనా ఒక చిన్న డిస్టర్బెన్స్ వస్తుంది సార్ మీతో పాటుగా.
Another obsolete concept is the limited estate. That also we will deal in short. So before going into the property, concept of property, we have to take in mind all these things. Put along bond. Yeah, from this, now if we start, the basic element, what we have now touched is, in the ancient times or for the first time in the original, it is called the right of occupancy. Occupancy means you don't go to any special law or tenancy laws with reference to occupancy rates. Because at the earliest point of time and in the ancient times, there was nobody to convey any property to anybody. Those who occupied the properties began exercising the rights of ownership, and from their way or the behavior in which they are exercising the rights on a particular or a definite object, these principles have been formulated that this is the ownership, this is the position, and this is the right. And thereafter, when the property passes on from one person to another person, it is called the derivative interest or the derivative title. So now we are dealing with only the derivative title and how the derivative title has been regulated by the provisions of Transfer of Property Act. So here and there, whenever the particular provision has been required to be referred, we will touch the provision. So the another classification of these properties is corporeal interest and incorporeal interest. Corporeal interest means it is an estate or which they are writing presently success. That means the interest in the property which one is having immediately. He can enjoy the property. There is no question of postponement. Incorporeal interest means the right has been incorporated, but the enjoyment of the property has been postponed to a later point of time. That is called the incorporeal interest. This in detail we will leave in the last chapter while dealing with the vested interest, contingent interest, conditional interest, and other interests which now our friend Mr. BGK has referred to during the course of his introductory remark. During the course of incorporeal interest, where a particular individual has been the right at a later point of time, which cannot be noticed by individual. Because how can we know? For us, it appears that X is the owner of the property. We do not know whether X has created any right to any particular individual to be given effect to after his lifetime or after the lifetime of somebody else or at a later point of time. So till this right has been vested, initially in England, the chancery courts have been considered these incorporeal rights as rights of equity. In India, equitable rights or the rights of equity has no specific difference, but they are also having a statutory recognition and which have been granted by the courts at the discretion. They are called the equitable rights. Equitable rights are originally started by the chancery courts, which have been granted by the principles of equity, justice, and good conscience. That is a fair deal. Fair deal where certain informalities also have been set aside and they have been kept aside. And the right of a particular individual who has been inducted in a particular property or who a right has been incorporated to him has been recognized by the courts of equity. Those rights were not visible or not perceivable. So how they can be known? Because when once a particular property has been purchased by a particular individual, highest standard of diligence have been put on by the equity courts on him for the purchaser. So therefore, how they can be known? In the course of the judgments, equity court developed the concept of the doctrine of notice. Notice means initially this notice is only with reference to the incorporeal interest, and as a matter of constructive notice, it has been developed. Constructive in the sense, before getting transfer of a particular property from a particular individual, the transferee is having heavy burden to notice whether he is having an interest in the property absolutely, or whether his rights are plenary to transfer the property, and whether he can get the property or not, or somebody else is having any interest in the property. The instances in those days were minors' contracts and the person in possession of the property, lessees or the licensees, or other persons who are in possession and enjoyment of the property under a particular juror relationship with the original owner of the property. These interests were sometimes called as a hidden interest, but they were actually enjoying the property. And therefore, the doctrine of notice, the chancery courts used to ask a particular individual, have you not noticed the fact that some X is in possession of the property? You started to purchase the property from Y. You started bargaining, but are you not supposed to inquire why that particular third person, that X is in possession of the property? What is his interest? Unless you know that interest, how can you claim that you are the bona fide purchaser or you are the bona fide transferee? We need not confine to purchase. Any transferee for consideration. Any transferee for consideration without having knowledge of a prior transaction. Prior transaction of any kind. Because again, I am recalling the Transfer of Property Act does not deal with only the plenary right. Transfer of plenary right only. Though it says that is to regulate the transfer of property. Regulate the transfer of property means property is equated to ownership and ownership is equated to property. Both words have been used as synonymous. So when the property has been just a short repetition, a property has been confined as a bundle of rights or the interest, any interest can be transferred by a plenary owner to anybody. He can split up the rights, he can detach the rights. He is having only a residuary right in the property after transferring some rights to third parties. That means, suppose if we lease out the property, what is his right? His right is only a right of resumption, either on the default of the lessee or after the termination of the lease period. If he mortgages the property, mortgage means transfer of an interest in the property, but it is not the transfer of the whole property except in English mortgage. It is one interest. If he is usufructuary mortgage is in possession of the property, and when the mortgagor wants to dispose of the property, the transferee is supposed to inquire why somebody else has been enjoying the property, why he is putting the property for sale. So these are the fundamental things which warrants a particular person to know something. That's why the notice has been developed, and doctrine of notice contains two elements. One is the actual notice and another is the constructive notice. In course of time, a third kind of notice also has been attributed, that is called the imputed notice. Actual notice means the person who is actually having knowledge of the interest of third persons in the property. Constructive notice means the person who wants to get a transfer of property finds that somebody else is in possession of property or somebody else is having some interest in the property, but it is not clear for him. In such case, he is supposed to put an inquiry on that fact. If he did not make any inquiry because of his gross negligence, because of his abstention from inquiring into that fact, if he purchases the property, he can never be called as a bona fide purchaser, and he will be called as the bona fide transferee with the constructive notice of a previous transaction by the same transferor. That is called the constructive notice. And then the imputed notice. Imputed notice means notice has been imputed by the court during the course of the business of agency. Business of agency means suppose a power of attorney has been given by one particular individual to another to deal with the property. Power of attorney holder is also authorized to dispose of the property. Both of them must have in communication with the transaction. There shall not be any communication gap between the two. Suppose during the course of agency, if the agent has disposed of the property without the knowledge of the principal, courts or law says that the principal is having knowledge of the transaction entered into by the agent. That is called the imputation. Knowledge is imputed by the court. And therefore, that is only, we have to see, that with reference to the notice of agency, notice of the transaction of agency. Transaction of agency means with which the power has been given to him. Thus, the courts of equity developed the concept or the doctrine of notice during the course for purpose of protecting the equitable interests which are held by the persons under a particular transfer. This principle we are having in section 3 of the Transfer of Property Act. There, the definition of notice has been given with 2 explanations or 3 explanations given in this. The explanations are the same thing. A position is a constructive notice and registration of the document is a constructive notice, and where a person who is having the constructive notice of the fact is supposed to go on inquiring into the fact till he has got the clearance of doubt with reference to the title to the property. In such case, he can never be called as a bona fide transferee. So the concept of registration, how amount of constructive notice means, that's why we always used to call the party first to get the EC. EC means encumbrance certificate, all our friends knows. In the encumbrance certificate, the transactions will be entered into name of the executant, name of the claimant, date of execution, date of presentation, date of registration, subject matter of property, etc. That is index. So to impute constructive notice, that index should be properly made in the registrar office. That is the only condition which has been stipulated by the Transfer of Property Act. So unless those particulars are correct and assured particulars, we cannot call that it gives a constructive notice to a particular individual. So that care we have to see. That's why, as a matter of additional care, we are also calling that there should be some search. So better a certified copy of the document shall be obtained from the registrar's office after, according to the particulars mentioned in the EC. So that is called the inquiry. So that further inquiry leads him to know something else. So after that, whether he has to ascertain the title. This is called the notice. After this, we have to see what is transfer of property. Why we start with this question? The transfer of property means I have already told that the Transfer of Property Act deals with the transfers which are derivative. Derivative means transfer of property means a property which has been conveyed by one living person to another living person. One living person to another living person. Why this stress has been given? It is the definition has been given under Section 5 of the Transfer of Property Act. And Section 5 says that transfer means a conveyance. So definitely there should be a conveyance of property. That should be between 2 particular individuals who are living persons. And explanation is given that living persons means juristic persons also are the living persons. Associations, companies, societies. Of course, the right to acquisition or right to disposition of the property has been controlled insofar as the companies, societies, and associations are concerned, according to the enactments under which they have been constituted or incorporated, or according to their bylaws. Those are the only restrictions. But the companies and associations are also come within the living persons. This is called the transfer inter vivos. Converse to it is the transfer ab testamento. Disposition ab testamento or the transfer ab testamento. That means a person who disposes the property by will, which is totally governed by Indian Succession Act. Because the transfer affects only after the lifetime of the testator, and it is always capable of being amended, modified, revoked, or cancelled. It is always in ambulatory period during the lifetime of the person who transfers. But here under Section 5 of the Transfer of Property Act, and once the property has been conveyed, this property either forthwith or at a later point of time, or conditionally or unconditionally, absolutely, or only particular interest, whatever it may be. So that is the only definition given, but except that there is no definition. Why the word conveyance has been used means, conveyance means one person is divesting with his rights and another person is vesting some rights in the property by reason of the transaction made between the two. That is called the conveyance. Without divestment, there is no conveyance at all. We are also seeing so many instances where the parties have been relinquishing the already existing rights in favor of the real owner, a benamidar, and the real owner of the property, or joint owners. In two joint owners, without making any partition, they may release the right of this other co-owner. These are all where there is no divestment and simply recognition of the property. There is no conveyance at all, and it is not the transfer of property within the meaning of transfer of property. For other purposes, we have to go to section 17. 17 of the Indian Registration Act. That's why in the very operative part, the Transfer of Property Act says that in section 4, that the provisions of Transfer of Property Act shall be read as supplemental to the Indian Contracts Act and the Indian Registration Act. Because section 17 of the Indian Registration Act says a particular definition for purpose of registration. What it says, creating, extinguishment, declaring, abrogating, or derogating any interest in the property by means of a particular instrument. And if that instrument is a non-testamentary instrument and the subject matter of the value of the property covered by the instrument is 100 rupees or upwards, it shall be compulsorily registrable. That is one mode of registration. The one mode of conveyance, and the definition given, even though it is not the transfer, it should be in writing, it should be registered within the meaning of section 17. Here, under section 5 of the Transfer of Property Act, what we see is unless it amounts to conveyance, unless there is an element of divestment, we cannot say it is a transfer. That is the concept of transfer. So what can be transferred and what cannot be transferred? That is the next question. That is a list enumerated in section 6 of the Transfer of Property Act, prohibiting certain items which cannot be transferred. That list can be self-evident, except here and there few clauses which requires explanation. And for that purpose, I made an introductory remark with reference to the concept of ownership by the time of passing of this act. So in this reference, if we go under section 6, the chance of heir apparent succeeding to an estate, the chance of relation obtaining a legacy on the death of a kinsman or any other, or mere possibility of like nature cannot be transferred. That is the very first exception which we have to bear in mind. Chance of succession, or this is called otherwise a spes successionist. That means we may feel that the property will be succeeded by us. One may feel that I am the only son of my father and there are no other individuals. My mother also passed away. But on the death of my father, the property will completely devolve on me. And therefore, I can dispose of the property. Today, I am in need of some money. If I will execute the document after the death of my father, you take possession of the property. Can we say that particular transaction is a valid transaction or a void transaction? This is called the transfer of spes. That is a prohibited transfer under section 6 of the Transfer of Property Act. Because until his father dies, he cannot say whether he can be succeeded or not, unless he is also having a pre-existing right in the property. That is a totally different question. Then we cannot call it as a spes. Spes means definitely the property is a self-acquired property, and which property can be succeeded in other circumstances if his father passes away. So before his father passed away and before succeeding the interest, anticipating the succession, he cannot dispose of the property. That is the first prohibition, because he was not having any title to the property, and his father may execute any will, or he may sell away the property, or may give the property to some other person, or may gift away, or he may create a trust, or he may give it to charity. In any way, and ultimately by the time of the death of his father, whether he gets the property or not is a material question. Suppose if he gets the property after the succession and after the document has already been executed even prior to the succession, that principle has been governed elsewhere. That is called the feeding estoppel. In the next class, that we will discuss. Now, other restriction is a mere right to entry on a breach of contract. That is usually in the case of the transactions between the plural relationships. That means lessor and lessee, licensor and licensee, or anybody who has been inducted by the owner in the property, with the condition that on a particular default committed by the enjoyer of the property, he may resume the property. So this is also just like a anticipating default or anticipating that he can resume the property on a particular point of time, even before the default has been committed. A person is not entitled to transfer the property with the direction that he can take possession of the property after the person in possession has committed default. That is also prohibited. That is prohibition of mere right of entry. And then the question of easement. Easements are always their rights which have been exercised on the property of some other individual. They are not the personal rights or the proprietary interest of a particular individual who owns the property. That's why if he wants to transfer the easement, that means right to way, right to water, and right to fell the trees, just like other than natural rights, whatever the easements which have been created an intangible interest in the property, if he wants to transfer the property, he shall transfer the dominant tenant also. Otherwise, he cannot. Servient tenant and dominant tenant both are there, and without transferring the proprietary interest, he cannot transfer the easement. That is another provision. And then the property restricted to the personal enjoyment. This needs some explanation to our young friends who are not having opportunity to go through the cases on hand also. I have made an introduction to this. Earlier, there were service enams. In the service enams were burdened with service. Archagaton service. Archagaton service means a priest of a temple is entitled to enjoy the property as long as he is entitled to render service to priests. And some properties have been given to temple for performance of daily pursuits in the temple, just like Dopadiyapana Vejas, they are called. As long as they are being performed by Archaka, he can enjoy the property. When once he shall not, when he stops the performance in the temple, he has to quit the property. But he cannot transfer the property and he is not the absolute property. Just like all service enams, personal services in the estate, carpenter service, cobbler service, goldsmith service, blacksmith service, Karanam service, these are all the services, and they were giving some honorarium only, except the giving a right to enjoy the usufruct on the property without giving any right of alienation or without giving any right or title to the property. These are called the estates or the properties which are restricted for the personal enjoyment of a particular individual, and these properties cannot be transferred. These properties cannot be transferred. And now in the present days, what we are seeing is that the known examples are the provisions of Act 9 of 77. An assignment has been made by the government to the landless poor, and the deformed pattas have been given. And those documents clearly restricts that a property cannot be transferred. A property can be enjoyed only by the grantee or the pattadar. In previously, prior to passing of Act 9 of 77, 12 years enjoyment was the minimum period which has been prescribed by the government for the enjoyment of property. But after passing of the Act 7 of 77, notwithstanding any term or any condition or term mentioned in the patta or the grant by which has been inducted in possession of the property, a grantee from the government under D form cannot transfer the property. Suppose if we transfer the property, it is absolutely invalid and the government is entitled to resume the property. Maybe, of course, that the incidents are there where he has been given first opportunity for resumption and after the second opportunity is totally forfeited. That is all the incidents that act. But here, to this extent, what we have to see is that an estate which has been personally restricted for the enjoyment cannot be transferred. Then other restriction is the transfer for future maintenance. These transfer earlier also, one thing my friends may note point, major amendment have been passed to Transfer of Property Act in 1929. Till 1929, law was totally different and there was judicial controversy with reference to the rights. To remove all the controversies, the Law Commissioner suggested major amendments to the Transfer of Property Act, and in 1929, so many amendments have been made. Exhaustive amendment has been made to the Transfer of Property Act. Prior to that, with reference to the maintenance, there were divergent opinion whether a maintenance can be transferred or it cannot be transferred. Some court says that when once a decree has been passed by the court granting maintenance, it has become the vested right of the maintenance holder and it is a liquidated sum which can be transferred at least either as an actionable claim. A beneficial interest in the property, it has become the beneficial interest in the claim. Just like a transfer of decree, it can be transferred. But later after the amendment, it has been made clear by the legislature that right of maintenance or right to future maintenance can never be transferred. That is a strict prohibition under Section 6 of the Transfer of Property Act, because always the maintenance right is an imperfect right. Imperfect right, and it is not just in them. It is only a personal right, and that personal right can never be vested, and it is always variable, and it can be subject to variation. Then a mere right to sue. A mere right to sue also cannot be transferred. Right to sue means it is only a cause of action or an action. Cause of action means it is a cause for a remedy. From cause of action, there may be so many rights of actions. Here, what we have to see is whether the right to sue is for liquidated or whether the liquidated amount or a crystallized rights or whether it is only for unliquidated damages for a tortious liability or not. The distinction is maintained by the courts to the effect that right to unliquidated damages can never be transferred, because we cannot say whether the unliquidated damages can be granted or not. It is not arising out of the contractual obligations between the parties. We cannot say how much amount that will be granted, even though the court will grant the damages, whether it is mitigated damages will be granted or nominal damages will be granted, or sometimes the court may not grant the damages. So it is always unascertainable, unliquidated, and there is no guarantee at all. And that's why a care has been taken in the Transfer of Property Act under Section 6 that it can never be transferred. And other things are public office cannot be transferred, trust cannot be transferred, temples cannot be transferred. These are the other descriptions. They are self-evident and no explanation is needed on this. That is Section 6. Then we have to see the other concept is what is dispositive capacity. Dispositive capacity is the more important topic and concept in the Transfer of Property Act. Once again, I recall all my friends is that the Transfer of Property Act deals with the derivative rights. Derivative right means one person conveys the property to another person. To what extent he can convey the property? Here, what are the conditions that has been given? Conditions that has been prescribed by the Transfer of Property. Main dispositive capacity, referring to Indian Contract Act, what are the contract requirements for the contractual capacity of a particular individual or the contractual capacities in the dispositive capacity also. One person shall not be a minor, a person shall not be a lunatic, a person shall not be an idiot, a person shall not be under any disability to transfer the property. That is the dispositive capacity. Dispositive capacity in point of qualification. Section 7 says dispositive capacity means not merely that entitlement of the property, authority to transfer the property, whether the property as a whole, that the entire plenary right of ownership can be transferred, and whether the transfer can be absolutely or whether the transfer can be conditionally made, or the circumstances to which he is permitted to transfer the property can alone be made, or what is the extent and the manner how the transfer is to be effected. It is more comprehensive and the crux of the act. As far as section 7 is concerned, it says a person who is entitled for transferable property, that we have to mean whether he is entitled, that whether he is having any inherent right or a statutory right to transfer the property. Otherwise, he is not having a transferable property, he cannot transfer. Just now we have referred to it, which are the interests restricted only for personal enjoyment. Those properties cannot be transferred, and therefore under section 7, that with section 6, if we see that a person shall have a transferable interest in the property, that is one element. The second element is he must have the authority to transfer the property, though he is not the owner. Sometimes this transfer can be effected through power of attorney holder. That is covered by section 7 of the Transfer of Property Act. Not only the owner can transfer the property, but also the agent of the owner can transfer the property if the agency is more comprehensive with the power to transfer or alienate the property as be given and incorporated in the document. That is section 7. And the extent of property is whether wholly or partly or absolutely or conditionally. So again, in the next section, we will go to section 19, 20, 21, and 22. They deal with the transfer of interest, whether vested interest, that is the plenary interest, and vested interest with immediate right, or conditional interest, and in those conditional interests, whether the condition precedent or condition subsequent by reason of which a property once vested can be divested, or whether the property can be divested to resumed to the original owner itself, or on the default committed by one person, the property shall pass on to another. It is called the executive device. And the circumstances. Circumstances also is very much important, because this is also some obsolete concept, except we are seeing in Hindu law. Hindu law, we are seeing only in joint family now. Suppose if you take the joint family manager, what are the circumstances under which he can dispose of the property? Suppose if you take a Hindu widow, what are the circumstances under which she is entitled to dispose of the property? What are the conditions prescribed? This again we can see coupled with the section under section 38 of the Transfer of Property Act, which says how far a particular individual can transfer the property. A joint family manager is there. The manager's powers are only to the extent for the benefit of the family, for the benefit of the education of the minors, for the benefit of the welfare of the minors. You can dispose of the property who are having any pre-existing right or not in the property, and for the discharge of family debts, for any other paisa obligation, just like a Hindu widow's right. A Hindu's right till the woman's estate has been abolished, she was only having an equitable interest in the property. That is how it has been interpreted as an equitable interest. It is a sui generis to Hindu law only under section 14 clause 2, and subsequently it has been enlarged under section 14 clause 1. So under what circumstances I can dispose of the property? So if the maintenance amount has been not sufficient, can you dispose of the property? Or whether she can dispose of the property for the spiritual obligations of her late husband, and for making an adoption for the benefit and spiritual obligations of her husband, and for oblation theories, for Pradhana theories, and for her personal uses. And these are the limited circumstances under which she is entitled to dispose of the property. That was the earlier law. So all these things have been incorporated under Section 7 to the extent that a person who is having transferable interest in the property can dispose of the property to the extent and under the circumstances he is entitled to. That we have to stress upon. What are the circumstances under which he is entitled to transfer the property, and what is the extent or what is the limit? Then what is the extent and limit we have to see is the fundamental principle is no one can convey more than what he has. That is the fundamental principle. Beyond that, he cannot dispose. Suppose he is having only a life estate, he can dispose of the life estate. He is having only a vested remainder, he can dispose of the vested remainder only without disturbing the prior interest. That is the life estate holder. After the death of life estate holder, his transfer will take possession of the property, because the vested remainder interest also is a transferable interest in the property. These are two examples, because if we started, we will go deep into that particular point. So these are the two examples with reference to the extent what he is entitled to transfer the property, whether as a whole he can transfer the property, or whether he can transfer the property to the extent possible and to the interest he is having in the property. And then the manner allowed. And what is the manner allowed or manner prescribed by law? Basically, Hindu law did not contemplate any document in writing. And there is no particular procedure. Only the consensus between the parties is sufficient. If a person wants to transfer the property, is correctly understood by the transferee, and the bargain made by the transferee is correctly understood by the transferor, that is sufficient, and delivery of the tangibly moved property itself completes the transaction. That was the law. That was the law under Hindu, which was adopted by Hindus. But after passing of the Transfer of Property Act and the Indian Registration Act, these formalities and requirements have been started for purpose of completing a particular transaction, which is a conveyance and which amounts to a declaration of interest in the property, or abridgment of an interest in the property, or transfer of an interest in the property, or restricting, limiting, redeeming, whatever may be. When once the property has been touched and the value of which is 100 rupees or upwards, except in certain cases, it is compulsorily a registrable document. A registrable document means it is presupposes that it should be in writing and that it should be registered. That is a manner prescribed by law. So what documents are required to be in writing and what documents are not required to be writing has been contemplated wherever it has been mentioned under that particular chapter. Here, Section 9 of the Transfer of Property Act simply says that a transfer of property need not be in writing unless it is specifically required. That is the manner or the question prescribed. So what are the transfers which are required to be registered? Section 9 never says. And it also never says that a particular document is to be in writing. It simply says where the document is not required to be in writing, the document can be, the property can be transferred without any writing. So we have to go for search of other than oral transfers. So Transfer of Property Act itself is a self-contained code, and it says that Registration Act shall be read with supplemental to the provisions of this Act under Section 4. And it says that sale should be in writing and it need not be attested. Simple mortgage, it should be in writing and it should be registered irrespective of its value. Gift, it should be in writing and it should be registered irrespective of its value. Other specific transfers which have been provided under the Transfer of Property Act are compulsorily in writing and they should be registered. Only exception is again equitable mortgage. So we can find that equitable mortgage need not be registered. Only nowadays, for purpose of seeking the notice means the note the equitable interest of the property, it is also enabled that memorandum of equitable mortgage may be registered. That is called the EM registration. But always the memorandum of the equitable mortgage or the mortgage by deposit of title deeds is provided to facilitate the commercial transactions speedily and without any delay. For that purpose, if one person deposits the document and borrows the amount, that itself is sufficient. There is no record, there is no necessity to make any record, there is no necessity to make any memorandum. But in practice, as a matter of fact, for purpose of evidence, we are taking the record. So that oral transaction is sufficient. As a matter of fact, memorandum also is not a document of mortgage. It is only an evidence of transaction which has already affected, and that therefore the transfer which we can find under section 9. Section 9 is within the contemplation of section 9. Section 9 means section 9 did not make any enumeration. I am repeating once again. Within the meaning of section 9, we can find that equitable mortgage is the mortgage which does not require any writing. That is one thing. So this is a form of, then what are the attestable documents and what are not attestable documents? Except the sale, other specific transfers are required to be attested. Then what is called the attestation? That is another concept which we are having under section 5. Attestation has been defined under section 5 of the Transfer of Property Act and under section 63 of the Indian Succession Act. We have to read the provisions relatively to the Indian Succession Act and also the Transfer of Property Act, because the dispositions in both says only one is transfer inter vivas and another is transfer ab testamento, except in certain other circumstances. And therefore, what we can see and what we can observe is, when once a document is required to be compulsorily attestable, it is always to be attested by at least 2 witnesses. Then what is the mode of attestation? Mode of attestation in the sense means the attestor who attests the signature must see when the executant signs the document, and the executant also shall witness the attestor signing the document. That is called the attestation. The necessary element of attestation, what naturally emphasized and what is required is unanimous attesting. Because one may say that I simply attested the signature, but I did not know what the contents of the document. Then we cannot say it is a proper attestation. Unanimous attesting also is required. That means intention to attest to the document, intention to know the contemplations of the executant also sometimes. Execution means this is also called the formalities of transfer by execution, attestation, and the registration. These are the 3 formalities of the document to which the act has been provided. Execution means signification or the significance of the convey the person who is transferring the property or who is executing the document to the contents of the document. That is the acceptance or significance of his the contents of the document which are being incorporated therein for which he is signing. That is called the execution. Attestation means the attestor saw while the executant signs the document, and the executant saw while the attestor signs the document. And thereafter the document will be presented for registration, where the document should be registered by law. After the registration, the transaction will be completed. This to be supplemented by section 17 of the Registration Act. So, where the document is required either by section 54 of the Transfer of Property Act, or the mortgage, or the lease, or the gift, or the exchange, or the charge, or any document which has been required to be registered under section 17 of the Registration Act, we shall see the effect of the registration and the effect of non-registration of the document. They are called the informal documents. Informal document means informal documents are always not valid and always not valid. Section 17 contemplates that a document which is compulsorily required to be registered and has not registered, it cannot be looked into. It cannot be looked into for any purpose. Even for collateral purpose also it cannot be looked into. The courts are leaned upon to say that even to compare the signature of the document also, when once the document is compulsorily registrable, it is a bar on the court to receive the document. And therefore it cannot be looked into even to compare the signature. That is the most trigger. The only exception is under section 49. Section 49 of the Registration Act, which says in the suit for performance and for some collateral purpose to show the nature of the position of property, the document can be taken. But it never affects the transaction conferred by the document. It can never be made use for enforcing the rights under the document directly. That is section 49 effect. Then the other aspect is, suppose on the informalities, is there any exception we can find? Why section 49 says that in a suit for specific performance, the unregistered document can be looked into. Again, we have to fall back to section 53 of the Transfer of Property Act. This is also the doctrine of equity, which has been originally developed by the Chancery Court. More or less all equitable doctrines which are incorporated either in the Transfer of Property Act or in the Social Relief Act have been developed by the courts of Chancery in England. And those have been statutory recognition in Indian law. And generally says Indian law, there is no equitable estate. But Indian law recognizes the principles of equity and give effect to the rights which have been given in a different form. In a different form at the discretion of the court. And the principles are definitely different. A legal right is the right which can be claimed by a particular individual as of right, and the equation is sufficient, and under a particular section of law he is entitled for a right, the court can grant the right. That is the legal right. But where the equitable right, we want to enforce the court as to see the fairness and conduct of the party also in approaching the court, and what is the equity and why he did not complete the formalities of a particular transaction where it is required to be complete in a particular way. That is called the equitable relief. Equitable relief at the discretion of the court. That we can find coupled with section 49 of the Indian Registration Act and section 53A of the Transfer of Property Act. What section 53A says, where a particular transfer of immovable property has been made for consideration, that we have to bear in mind. A transfer of property has been made for consideration and signed by the party, but the document, it is properly stamped, but the document has not been registered according to the law under the law of registration. The transferee did not get any title to the property, but at the same time, when the transfer has been put in possession of the property, or if the transfer is already in possession of the property, his possession has been recognized in continuation of the transaction covered by the particular transaction, then the transferor or any of the persons who are claiming under the transfer are absolutely debarred from taking possession of the property. That is the contemplation of section 53 of the Transfer of Property Act. These we see usually in the agreement of sale with possession of property, where entire consideration has been paid or part consideration has been paid, but in part performance of that particular contract, if the transferee is put in possession of the property, he cannot be disturbed, he cannot be dispossessed. Whether it is an passive remedy or an active remedy, that is the next question we have to see. The courts are always explained, and the equity also says that is only a passive remedy which protects the person in possession of the property, and the bar is on the transferor not to disturb his position, but he cannot invade. He cannot invade on the position of the property, but the transferee cannot say any active right against the transferor not to interfere with the property. We have seen some instances where injunctions have been obtained by the persons on the ground of part performance of the contract, that they are under agreement in possession of the property and it is a permissive position. And injunctions were also confirmed. But exact law, what the principle is that where a particular individual has been entitled for the higher relief, he is not entitled for a simple injunction or an injunction simple sitter. When once he is entitled for the simple performance of the contract, when he is in possession of the property, he has to file a suit for physical performance of the contract, and he has to obtain a temporary injunction of protection to control the invasion against his possession of the property because he is in permissive position. So this is a passive remedy which has been recognized under Section 53 of the Transfer of Property Act. These are one of the informal transfers of the property where the transferee's position has been protected by the courts. These are the concepts. These are the concepts. Today, I want to make only an introduction to the concept, and therefore, on these concepts, while we're referring to the relevant sections of law, my junior and younger friends may develop the principle. In the next session, what we have to see is what are the interests we hold in the property. They are called the operation of transfer. Operation of transfer covering two important documents. One is established by grant, that is where a person who is having no title at the time of transfer of the property, but subsequently acquires the title of the property, then whether the title endures for the benefit of the transferor or endures for the benefit of transferee, that is one thing. And another doctrine we have to cover is Section 35, which is the doctrine of election, where a person, it is also an exception to limited quad habit and non-habit rule, because a person who cannot have a better title than what he has conveyed. That means there are transfers where a person who is not the owner, but ultimately the transferee is put an option whether to accept the transfer or whether to reject the transfer. These two transfers and the doctrines in the area of transfer we will discuss. Then modes of acquiring interest in the property. What are the modes of acquiring interest in the property? I put it for the interest of juniors as the last phase, because the divestitive capacity of the absolute owner, either conditionally or to the extent that what we have read in Section 7. So, whether he can give the vested right in the property, or whether he can create only a contingent right in the property, or whether he can create a right, but at the same time, conditions so provided that the right will be divested back up to some other person on the happening of a particular condition, that is called the condition precedent. And what are the rights of limited owners to transfer the property? And finally, we will see what are the rights of third parties in between the transaction between the contracting parties. Those transfers, that means the fraudulent transfers and the dispendence. With this, we can complete the general principles of transfer. If we go on telling today, it will become very boredom and you cannot bear also. Therefore, my request to all friends is, now next session's topic also I introduce, and my junior friends may go through those topics and get prepared on this, and let us see more. It will be an interaction session than a continuous lecture from one side. Thank you. Thank you so much.
Thank you, sir. Interactive session, sir. Sir, ఎవరైనా ఇంటరాక్ట్ అవ్వాలనుకున్న వాళ్ళు హ్యాండ్ రైట్ చేస్తే నేను వాళ్ళని అన్మ్యూట్ చేస్తాను.
అప్పుడు మనం ఫస్ట్ వచ్చేస్తాం.
సార్ నమస్కారం సార్.
నమస్తే, చెప్పండి
సార్. నేను ఫ్రెషర్ సార్. చిన్న 2 డౌట్స్ ఉన్నాయి సార్.
చెప్పండి
సార్. ఇప్పుడు ఏ టెస్టేటెడ్ ట్రాన్స్ఫర్డ్ టు ట్రాన్స్ఫరీ ఫర్ లైఫ్ ఇంట్రెస్ట్, అబ్సల్యూట్ ఇంట్రెస్ట్ లేకుండా లైఫ్ ఇంట్రెస్ట్ మాత్రమే ట్రాన్స్ఫర్ చేసినప్పుడు ద ట్రాన్స్ఫరీ సేల్ చేయడానికి ఏమైనా ఎలిజిబిలిటీ ఉంటుందా సార్?
అంటే ఈ కాన్సెప్ట్ ఎలా వస్తుందంటే, ట్రాన్స్ఫర్ plenary right means the ownership as a whole. Transfer of property deals with the transfer of an interest in the property. Interest in the property means, and not merely the whole interest, but also one of the interests. One of the interests is to enjoy the property. For whatever the object it may be, an interest has been created for a particular individual to enjoy during the life. It's called the life estate holder. When life estate has been given, the transferor has to show ultimately the final benefit to whom it goes. That is called the ultimate benefit or the executory device. The executory device means ultimately to whom the final interest pass on. It shall not simply leave the vested life estate. So what is remained is called the vested remainder. That is the remainder interest. Because it has already given a life estate to you. So that means right to enjoyment is transferred. Then the remainder interest is right to hold the title to the property. Whether that right to hold the title to property is reserved by the owner himself, that is the transferor, or has given to somebody else. Now you have to see the life interest also can be transferable interest, but only to the extent of enjoyment. During the judicial precedents are developed like that. During the life estate holder, the transaction is valid, but she cannot convey the title. But the vested remainder is a transferable and heritable interest, so it can be transferred. The transferee under the vested remainder can take possession of the property after the life estate holder passes away. Suppose if any further immediate requirement is there, both the vested remainder and the life estate holder, both of them can jointly transfer the property, so that the person in possession of the property who is entitled to retain is conveying the possession, and the person who is entitled for the title at a later point of time is conveying the title. Thus the transfer is regularized. That we have to see. So it is detachable interest. That's what this says. That is the modern concept. Modern concept, even right from the auction also. It also says that the rights can be detached, and after detaching, what right remains with the transferor is called the residuary right, and after the transfer right has been for a limited period, is surrendered back to him, again the residuary right will lapse, and again ownership will be entire into plenary right. So definitely the vested remainder can be transferred, and life estate to the extent permitted can be transferred. Clarified?
Yes, sir. Okay.
Hello, clarified?
Yes, sir. This is offline, sir. Mute will be.
Gokul Krishna ఏదో అడుగుతున్నారు చూడండి.
Patnagar Jones.
Sir, clarified, sir. And another small doubt. ఇప్పుడు అటెస్టేషన్ లో మినిమం 2 witnesses ఉండాలని చెప్పారు, అండ్ ఇండియన్ ఎవిడెన్స్ యాక్ట్ లో 1 witness is enough అన్నారు. దేనికి ఓవర్ రైడింగ్ ఎఫెక్ట్ ఉంటుంది సార్?
క్లారిటీ లేదు. 2 witnesses are compulsory,
బట్ ఇండియన్ ఎవిడెన్స్ యాక్ట్ ఇస్ సేయింగ్ ఫర్ ఎగ్జిక్యూషన్ ఆఫ్ ఎనీ డాక్యుమెంట్ ఏదైనా ఒక టైటిల్ ప్రూవ్ చేయడానికి 1 witness is enough అని చదివాను సార్.
ఎందులోను?
ఇండియన్ ఎవిడెన్స్ యాక్ట్ ఫర్ జనరల్లీ
రూల్స్ ఆఫ్ ఎవిడెన్స్ లోకి వెళ్తున్నారు మీరు. టోటల్లీ డిఫరెంట్, అండ్ రిసెప్షన్ ఆఫ్ డాక్యుమెంట్ ఇన్ ది కోర్ట్ ఈస్ టోటల్లీ డిఫరెంట్. సో ఇఫ్ యూ వాంట్ ది వ్యాలిడ్ ఎగ్జిక్యూషన్ ఆఫ్ ది డాక్యుమెంట్, you have to get the document attested. Suppose you take the case of a will, what section 63 says is it should be attested at least by 2 witnesses. In the transfer interviews, if you go, now we have discussed the different transfers which are required by the Transfer of Property Act, which are to be attested. There should be attestation. Always means you bluntly make it a point that it should be by 2 witnesses. If there are no witnesses, the court cannot receive the document. For reception of document, to give the power to the court and to give the right to the person who is relying on the document, the Evidence Act contemplates that at least 1 witness should be examined before filing the document. Unless the witnesses are not available either by death or by reasonable explanation they cannot see. So for that, other modes are there, how to prove. But proof of attestation is required. For that, 2 witnesses need not be necessary. Only 1 witness is sufficient. That is rule of evidence.
నైస్ రా.
చెప్పండి సార్. మిమ్మల్ని చూసి భయం వేస్తా నాకు.
ఫస్ట్ థింగ్ ఒకసారి ఏంటంటే ఈ డౌట్స్ అడిగినప్పుడు నా చిన్న సజెషన్ ఏంటంటే వాళ్ళకి తెలుగులో సమాధానం చెప్తే మనకు కొంచెం వాళ్ళకి అర్థమవుతుందేమో అని అనుకుంటున్నాను. అదొకసారి మీరు ఆలోచించండి. నెక్స్ట్ సెషన్ కూడా మీదే ఉంది కాబట్టి వాళ్ళకి కొంత అర్థం అయ్యేటట్టుగా మనం చెప్పగలిగితే బాగుంటుంది నా ఉద్దేశం. ఒకసారి అదొకటి మీరు కన్సిడర్ చేయండి. సెకండ్ ఆస్పెక్ట్ ఒకటి ఏంటంటే
అలవాటు పడిపోయి అలా పడిపోతున్నాం
అని నేను కాదట్లేదు సార్. అంటే జూనియర్స్ కి ఇంట్రెస్ట్ లో మనం ఈ సెషన్స్ పెడుతున్నాం కాబట్టి you can consider it and take the decision. So as attestation is concerned, నా డౌట్ ఏంటంటే attestor need not know the contents of the document. Attestation does not prohibit the persons to claim rights in the property. అంచేత attestation కి knowledge of the contents of the knowledge of the document అవసరం అయ్యేది లేదు. ఒకటే ఆస్పెక్ట్ ఉంది దాంట్లో ఏంటంటే attestation కూడా పార్టీ వచ్చి నేను ఆల్రెడీ సైన్డ్ అని చెప్తే he can attest the document. So attestation దగ్గర వచ్చేటప్పుడు documents need not be signed in these attestar's presence. That is the both principles must be known to the juniors. అటెస్టేషన్ అంటే వాళ్ళు వచ్చి చెప్తే నేను సంతకం పెట్టాను బాబు నువ్వు సాక్షాంతకం పెట్టేటప్పుడు కూడా సాక్షాంతం పెట్టిస్తే ఇట్ విల్ బి డీమ్డ్ ఎ వ్యాలిడ్ అటెస్టేషన్. సో అదొక ఆస్పెక్ట్ అండి. రెండోది ఇప్పుడు నాకు ఆస్తిలో వాటా ఉంది, నేను డాక్యుమెంట్ అటెస్ట్ చేస్తే వాట్ ఆర్ మై రైట్స్, వెదర్ ఐ కెన్ వెదర్ ఆ పార్టీ వచ్చి బై నువ్వు అటెస్ట్ చేసావు కాబట్టి ఏమైనా అడగచ్చా అనేది మీకు తెలుసున్నదే. డాక్యుమెంట్ దట్ ఈస్ ఎస్టాప్డ్. He is stopped from contending that he has got rights in the property because with the knowledge, if the party can prove that he attested the document with the contents, knowledge of the contents. అదొక్కసారి కొంచెం మన జూనియర్లకు ఎన్లైటింగ్ చేస్తే రేపు పొద్దున ఉత్తర మనం ఎవరైనా చేసినప్పుడు కూడా అబ్బాయి నాకు అతను అటెస్టేషన్ చేశాడు తెలుసుకునే కంటెంట్స్ తెలుసుకుని అటెస్ట్ చేశాడు అని చెప్పేసి మనం ఎవిడెన్స్ లో ఎస్టాబ్లిష్ చేయగలిగితే he is stopped from contending that he has got rights in the property. ఈ రెండు కూడా కొంచెం జూనియర్స్ ఎన్లైటింగ్ చేయండి. అటెస్టేషన్ మనకి ఆస్పెక్ట్ అది చూద్దాం అండి. ఇంకేమైనా మెథడ్ డౌట్స్ అయితే మనం చూద్దాం. మీరు చెప్పినట్టుగా కరెక్ట్. సెక్షన్ 68 ఆఫ్ ఎవిడెన్స్ యాక్ట్ ఇస్ డిఫరెంట్ ఫ్రమ్ అటెస్టింగ్ ది డాక్యుమెంట్స్. అటెస్టింగ్ మనకి అటెస్టేషన్ అంటే ఇద్దరు డాక్యుమెంట్స్ ఉండాలి, కానీ ప్రూవింగ్ ఆఫ్ ది డాక్యుమెంట్స్ ఈజ్ అండర్ సెక్షన్ 68 ఆఫ్ ది ఎవిడెన్స్ యాక్ట్. సెక్షన్ 68 says you have to examine at least one of the attested. అది లేకపోతే అలాగే సెక్షన్ 69 ఉంది. మీకు తెలిసింది మీరు తెలియదు ఏం కాదు. అంటే జూనియర్లకు తెలియని వాటి కోసం చెప్పి కొంచెం అనలైటింగ్ చేద్దామని ఉద్దేశంతో మేము ఇంటర్ఫీర్ అయ్యాను. సారీ ఫర్ ది ఇంటర్ఫరెన్స్. చూడండి చేద్దాం.
ఇంటర్ఫీరెన్స్ కాదు, ఇంటెలిజెన్స్. ఇంటెలిజెన్స్ ఇస్ ఇన్వైటెడ్. నేను చెప్తున్నాను గోకులకృష్ణ గారు చేతున్నారు చూడండి అని అలాగ అంటూ ఉంటాను, మీరు భయపెడుతున్నారని.
నేను చూస్తున్నానండి. లేదు చెప్పేది కొంత జూనియర్స్ బెనిఫిట్ గా ఉంటుంది.
అసలు నేను కాకపోయినా ముందు మా మేడం గారు బిజీగా చేస్తున్నారు, ఆయన పిలవరు ఏమిటంటున్నారు.
అది తెలుసు కదా మనం కేసు మనం ఎలా చేస్తాం.
ఈ యానిమస్ అటెస్టాండీ మీద ఒకసారి తెలుగులో చెప్తాను, అప్పుడు ఆ క్లారిఫికేషన్
అది వచ్చేస్తుంది. అది అంచేది తెలుగులో చెప్తే వాళ్ళకి అర్థం అవుతాయి.
నేను చెప్తున్నా అన్నాను, నేను చెప్తున్నా అలా స్పీడ్ గా చెప్పుకుని వెళ్ళిపోతే వాళ్ళని ఎవరు బోర్ కొట్టేస్తుంది. తెలుగులో చెప్పిన కాస్త హాయిగా ఉంటుంది అందరికీ అని అలవాటు కొద్ది అలా చెప్పేస్తుంది. అలవాటు అవుతుంది. అందులోకి 5 years నుంచి ఇక్కడ ఇంకో టైప్ కదా.
చెప్పండి.
కాన్సెప్ట్ ఆఫ్ అటెస్టేషన్ లో యానిమస్ అటెస్టాండీ అన్నారు. జ్యుడిషియల్ ప్రెసిడెంట్స్ కొంతసేపు వదిలేద్దాం, కొన్ని ఇలాగే చెప్తాయి, కొన్ని అలాగే చెప్తాయి. వెరీ సీరియస్ డిస్ప్యూట్స్ వచ్చినప్పుడు దాంట్లో కంటెంట్స్ దాకా వెళ్ళేరా లేదా అన్నది మెయిన్. అటెస్టేషన్ అంటే ఓన్లీ హీఈస్, మళ్ళీ తెలుగులోకి వద్దాం. అటెస్టేషన్ అంటే ఈ సాక్షి దస్తావేజు ఎగ్జిక్యూట్ చేయడం చూసారా లేదా, మెయిన్. దానికి ఎగ్జిక్యూషన్కి డెఫినేషన్ ఎలా ఇచ్చారు? ఎగ్జిక్యూటెంట్కి కంటెంట్స్ ఆఫ్ డాక్యుమెంట్స్ తోటి కన్సెంట్ ఉందా లేదా అంతవరకు ఎగ్జిక్యూషన్. దాన్ని సైనింగ్ అండ్ సిగ్నేచర్ అన్నారు. దాని డెఫినేషన్ ఎగ్జిక్యూషన్ మీన్స్ సైనింగ్ అండ్ సిగ్నేచర్. అటెస్టేషన్ అంటే విట్నెసింగ్ దట్ సైనింగ్ అండ్ సిగ్నేచర్ ఆర్ గెటింగ్ ఎక్నాలెడ్జ్మెంట్ ఆఫ్ దట్ సైనింగ్ అండ్ సిగ్నేచర్. రెండు. అంటే వీళ్ళు స్వయంగా చూడొచ్చు, ఇద్దరు సాక్షులు ఉండవలసిందని ఇద్దరు ఒకసారి చూడక్కర్లేదు. దస్తావేజ్ రాసిన వ్యక్తి నేను డాక్యుమెంట్ రాశాను, ఈ సంతకం నాదే, మీరు సాక్షి సంతకం చేసి పంపించండి అని డాక్యుమెంట్ పంపించవచ్చు. వాళ్ళ ఇంటి దగ్గర ఉండి కూడా వాడు సాక్షి సంతకం చేసి పంపించవచ్చు. యానిమస్ అటెస్టాండీ అంటే ఆల్వేజ్ నెవర్ ఎక్స్టెండ్ టు ది కంటెంట్స్ ఆఫ్ డాక్యుమెంట్. అది డాక్యుమెంట్ కంటెంట్స్ వరకు వెళ్ళదు. డాక్యుమెంట్ కంటెంట్స్ వరకు వెళ్ళడం ఎప్పుడు ఉంటే ఎటెస్టార్ ప్రాపర్టీ కూడా దాంట్లో ఇన్వాల్వ్ అయిపోయి అంటే ఫ్యాక్ట్లోకి వెళ్ళిపోతాం మళ్ళీ. అది డిఫరెంట్. కొంచెం జనరల్గా ఏంటంటే మన అడ్వకేట్స్ అయ్యేటప్పటికి ఈ ప్రాబ్లం వస్తుంది, ప్రోస్ అండ్ కాన్స్లోకి వెళ్ళిపోతుంటాం. లీగల్ ప్రిన్సిపల్ మన యాజ్ లా స్టూడెంట్ చెప్పుకోవాలి అంటే ఎటెస్టార్కి దస్తావేజ్ కంటెంట్స్ తోటి నాలెడ్జ్ ఉండవలసిన సంబంధం లేదు. దట్ ఈస్ ఫస్ట్ థింగ్. సెకండ్ థింగ్ ఏంటంటే ఇద్దరు ఎటెస్టార్స్ ఒకేసారి ఆ దస్తావేజ్ రాసిన సంతకం పెట్టడం చూడక్కర్లేదు. రెండోది దస్తావేజ్ రాసిన అతను కూడా స్వయంగా కూడా సంతకం పెట్టక్కర్లేదు. అతని డైరెక్షన్స్ తోటి ఎవరైనా కూడా అతని పేరు రాయొచ్చు, అది కూడా సంతకం అవుతుంది. ఒకవేళ వేలిముద్ర వేయాల్సిన పరిస్థితి వస్తే ఇప్పుడు ఎక్స్ప్లెనేషన్ కూడా రాస్తున్నాము. పూర్వం ఏంటంటే క్రాస్ ఎగ్జామినేషన్లో రాబట్టుకునేవారు, ఆయన ఇంజనీర్ కదా వేలిముద్ర ఎందుకు వేసాడండి, ఇలాంటివన్నీ. అంచేత సిగ్నేచర్ కరెక్ట్గా ప్రూవ్ చేసుకోగలిగితే సిగ్నేచర్ ఒకటి ఎసెంట్ ఆఫ్ కంటెంట్స్. అటెస్టేషన్ అన్నది ఎసెంట్ ఆఫ్ సిగ్నేచర్. దాన్ని యానిమస్ అటెస్టెండీ అంటారు. నేను ఎందుకు సంతకం పెట్టానో నాకు తెలియదండి, ఆయన ఏదో పెద్ద ఆయన గోకులకృష్ణ గారు కదా నాగేశ్వరరావు సంతకం పెట్టేయండి అని పంపించారని చెప్పేసి నేను సంతకం పెట్టిస్తాను, నేను అటెస్టేషన్ అనుకోలేదు. అది ఇలాంటి వాదాలు ఏమైనా డెవలప్ చేసినప్పుడు యానిమస్ అటెస్టాండీ ఉందా లేదా ఇలాంటి క్వశ్చన్స్ వస్తాయన్నమాట. అందుకని ఇప్పుడు మనం కరెక్ట్ స్ట్రిక్ట్గా చెప్పుకోవాలి అంటే సెక్షన్ 68 డాక్యుమెంట్ రిసీవ్ చేసుకోవడానికి ఒక అటెస్టార్ని ఎగ్జామిన్ చేయమన్నప్పుడు దాంట్లో యూజువల్గా మన నెంబర్ ఆఫ్ చీఫ్ ఎగ్జామినేషన్ చూస్తున్నాం, అందరూ ప్రాక్టీస్ చేస్తున్న వాళ్ళమే కదా. దాంట్లో మనం ఏమిటి రాస్తున్నాం? ఎక్స్ ఎగ్జిక్యూటెడ్ ది విల్, హీ సైన్డ్ ఇన్ మై ప్రజెంట్, ఐ అటెస్టెడ్ ది డాక్యుమెంట్, హీ సా మై సిగ్నేచర్ వైల్ ఐ am సైనింగ్ ది డాక్యుమెంట్, ఐ సా వైల్ హీ సైనింగ్ ది డాక్యుమెంట్. అంతే తప్ప ఆయన దానపట్ట రాశారండి, ఆ దానపట్ట ప్రకారం వాళ్ళ అబ్బాయికి ఆస్తి ఇచ్చారు, లేకపోతే వాళ్ళ తమ్ముడికి ఇచ్చారు, ఇవేం చెప్పం కదా. అంటే ఎగ్జాంపుల్ కోసం చెప్తున్నాను ఇది. అంటే దీన్ని బట్టే మనం చూసుకోవాల్సింది ఏంటంటే అటెస్టార్కి కంటెంట్స్ చూడవలసిన పని కానీ కంటెంట్స్ రుజువు చేయవలసిన పని కానీ లేదు. అతనికి ఎంతవరకు అంటే ఆయన రాశారండి, అది నా సమస్యలో రాశారు, లేకపోతే ఆయన రాటిఫై చేసిన తర్వాత అది ఆయన రాశారు దస్తావేజు, ఆయన సంతకం పెట్టారు అన్నాక నేను సంతకం పెట్టాను అని చెప్తే చాలు. యూజువల్గా మనం రొటీన్లో అడిగేస్తున్నాం, మీరు వెళ్ళిన టైం తర్వాత రెండో అటెస్టార్ ఎన్ని గంటలకు వచ్చారండి, అంతవరకు మీరు ఏం చేశారు, మీరు ఇద్దరు కబుర్లు చెప్పుకుంటూ కూర్చున్నారా, అసలు ఎక్కడుంది అలాగా ఇద్దరు ఒకసారి చేయాలని? ఒకరి తర్వాత ఒకరు చేయొచ్చు. చెప్పండి నెక్స్ట్ టైం.
పట్నాయక్ గారు.
సార్ హలో.
అదే సార్ మీరు మెసేజ్ టైప్ చేశారు కదా,
అదే సార్ నాకు సెక్షన్ 114 ఇండియన్ సక్సెషన్ యాక్ట్ ఇలిస్ట్రేషన్ అర్థం కాలేదు సార్, విత్ ఇంటర్లింకింగ్ విత్ రూల్ అగైన్స్ట్ పర్పెచుయిటీ. ఒకసారి అది ఎలాబరేట్ చేసి చెప్తారా సార్? 114
112 ఏ యాక్ట్ లో సెక్షన్ మీరు అదే 114 ఏ యాక్ట్ లో మీరు చేస్తున్నారు రిఫరెన్స్?
ఇండియన్ సక్సెషన్ యాక్ట్.
ఇండియన్ సక్సెషన్ యాక్ట్. ఇండియన్ సక్సెషన్ యాక్ట్ టాపిక్ లోకి మనం ఇంకా రాలేదు. టాపిక్ చెప్పండి ఒకసారి.
ఇట్ ఈస్ లైక్ రూల్ అగైన్స్ట్ పర్పెచుయిటీ మీద సార్.
అందులోకి వెళ్ళారా మీరు? అది మనం ఇంకా ట్రాన్స్ఫర్ ఆఫ్ ప్రాపర్టీ యాక్ట్ లో అంటే బ్రీఫ్గా ఇప్పుడు చెప్తాను మీకు, తర్వాత మన టాపిక్లోకి వెళ్తాం. నెక్స్ట్ సెక్షన్ అదే. దాంట్లో వచ్చేటప్పటికి ఇప్పుడు సెక్షన్ 13, 14 అండ్ 15 దాకా ఫండమెంటల్ ప్రిన్సిపల్స్ ఉంటాయి టీపీ యాక్ట్ లో. దాంట్లో అంటే రూల్ అగైనెస్ట్ పర్పెచ్యుటీస్ అంటారు. రూల్ అగైనెస్ట్ పర్పెచ్యుటీ అంటే అసలు పర్పెచ్యుటీ అనే మాటలోనే అర్థం ఉంది, ఫర్ ఎ లాంగ్ టైం, లేకపోతే చిరకాలం. అంటే ఒక ఆస్తిని ఎక్కువ కాలం పాటు ఏ రకమైన ట్రాన్స్ఫరు లేకుండా దాన్ని అలా తొక్కుపెట్టి ఉంచకూడదు అన్నది ఒక ప్రిన్సిపల్. అది రూల్ అగైనెస్ట్ పర్పెచ్యుటీ అన్నది ప్రిన్సిపల్ తప్ప దానికి ప్రత్యేకంగా ఒక మీనింగ్ ఉండదు. దానికి మన ఎగ్జాంపుల్ ఏం చెప్పుకుంటాము అంటే, సపోజ్ ఒక ఆయన ప్రాపర్టీ రాస్తారు, ఈ ఆస్తి నా జీవితకాలంలో నేను అనుభవించుటకు, నా అనంతరం నా పెద్ద కుమారుడు అనుభవించుటకు, ఆయన అనంతరం ఆయన పెద్ద కుమారుడు ఏ విధమైన దాన విక్రయాధికారంలో లేకుండా అనుభవించుటకు, ఆయన అనంతరం ఆయన రెండో భార్య కుమారుడు ఏ విధమైన దాన విక్రయాధికారం లేకుండా అనుభవించుటకు, ఇంకా అలా రాసుకుంటూ పోతూ ఉంటారు. ఆయన ఎక్కడ చూసినా దాన విక్రయాధికారాలు లేకుండా అనుభవిస్తూ 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 ఉండడమే అతని ఉద్దేశం. ఏమిటి అంటే, తన కుటుంబం దాటి ఆస్తి బయటికి వెళ్ళకూడదు, కొంతకాలం ఆ కుటుంబంలో, అంటే ఉద్దేశం మంచిదే, కొంతకాలం పాటు ఆ ఆస్తి ఆ కుటుంబంలో అలా ఉండాలి. ఆ కొంతకాలం అంటే ఏమిటి అంటే చిరకాలం. ఆ చిరకాలం అంటే దానికి అంతు బదిలీ ఏమి లేదు, తరతరాలు. మన దస్తావేజుల్లో కూడా అన్ని రాసిస్తుంటాం కదా. దాంట్లో ఏంటంటే మీరు, మీ వారసులు, మీ వారస్థానీయులు, ఆచంద్ర తారార్కం, సూర్యచంద్రాదులు ఉన్నంతకాలం, నక్షత్రాలు వెలుగుతున్నంతకాలం ఈ ఆస్తి అనుభవించడానికి ఏర్పాటు, అంతవరకు మేము మా వారసులు మీకు ఏ విధమైన నష్టం వచ్చినా మా సొంత ఖర్చులతో పరిహరించగలవారము. ఇది మా సంబంధం రాసి ఇచ్చింది, దాని పట్ల అంటాం. అసలు చంద్రమండలం వెళ్ళిపోయేదాకా, సూర్యమండలం వెళ్ళిపోయేదాకా మనం ఉంటామా? కానీ ఎక్కడో చోట ప్రాపర్టీకి పురుషాప్ అంటూ ఉండాలి కదా. అందుకని చెప్పి ఏమన్నారంటే, సరే ఉద్దేశం మంచిదే, మీకు ఫ్యామిలీలో ఆస్తి కొంతకాలం ఉంటే మీరు తరతరాలు అనుభవిస్తారు మీ కుటుంబం, కానీ ఎక్కడో చోట పురుషాప్ పెట్టాలి కనుక మీరు దానికి కొంచెం బ్రేక్ పెట్టండి అన్నారు. ఆ బ్రేక్ అంటే మీరు 3 జనరేషన్లు రాసినా పర్వాలేదు, 4 జనరేషన్లా పర్వాలేదు, లాస్ట్ జనరేషన్ దగ్గరికి వచ్చేటప్పటికి అందులో ఉండేవాడు ఎవడో ఒకడు మైనర్ మేజర్ అయ్యే వరకు మనం పెట్టుకోవచ్చు. అది దాటి రిస్ట్రిక్షన్ పెట్టడానికి వీల్లేదు. దాన్ని ఏమన్నారంటే పెర్పెచ్యుటీస్ అన్నారు. పెర్పెచ్యుటీస్ అంటే ప్రాపర్టీని శాశ్వతంగా బంధించి ఉంచుట అని. అది ఉంచకూడదు. ఏ ప్రాపర్టీ షల్ నాట్ బి టైడ్. ప్రాపర్టీ వెన్స్ వెస్టెడ్ ఆల్వేస్ క్యాపబుల్ ఆఫ్ బీయింగ్ డైవెస్టెడ్. ప్రాపర్టీని డైవెస్ట్ చేయాలి అన్నది ప్రిన్సిపల్. అది రూల్ అగైనెస్ట్ పర్పెచ్యుటీలో వస్తుంది. మనం ట్రాన్స్ఫర్ ఇంటర్వేవాస్ అని ట్రాన్స్ఫర్ ఆఫ్ ప్రాపర్టీ యాక్ట్ లో చదువుతాం. అది ఇద్దరు లివింగ్ పర్సన్స్ మధ్యన కనుక సాధారణంగా మనకి ట్రాన్స్ఫర్ టు అన్బోర్న్ పర్సన్స్ లో వస్తూ ఉంటాయి. వాళ్ళు ఏం రాస్తుంటారంటే, ట్రాన్స్ఫర్ టు అన్బోర్న్ పర్సన్ రాయకూడదు కదా, మరి ట్రాన్స్ఫర్ బిట్వీన్ లివింగ్ పర్సన్స్ అంటే. అందుకని ట్రాన్స్ఫర్ ముందర ఏంటంటే లైఫ్ ఎస్టేటు ఓ తల్లికో తండ్రికో ఎవరికో ఇచ్చి, వాళ్ళ అనంతరం వాళ్ళకి పుట్టబోయే సంతానానికి ఇచ్చి, మళ్ళీ వాళ్ళ అనంతరం వాళ్ళకి పుట్టబోయే సంతానానికి ఇచ్చి అలా వెళ్ళిపోతూ ఉంటారు కొంతమంది. అలాగ తరతరాలు వెళ్ళిపోతుంటే దానికి ఆ సైకిల్కి బ్రేక్ కొట్టడానికి రూల్ అగైనెస్ట్ పర్పెచ్యుటీస్ పెట్టారు. ఇదే ప్రిన్సిపల్ యాప్ టెస్టిమెంట్ అంటారు. యాప్ టెస్టిమెంట్ అంటే వీల్నామా. వీల్నామా అన్నది ఎప్పుడు కూడా ఒక వ్యక్తి చనిపోయిన తర్వాత కదా అమల్లోకి వస్తుంది. అంటే అది ఇవే క్లాజులు అందరూ కూడా రాస్తుంటాడు వీల్నామాలో, నాకు పలానా చోట ఉన్న ఆస్తి పలానా వాళ్ళు పలానా వాళ్ళు పలానా వాళ్ళు అని. అది కూడా ఇండియన్ సక్సెషన్ యాక్ట్ లో డీల్ చేస్తారు. అది రూల్స్ ఒకటే, దాని ప్రిన్సిపల్ ఏంటంటే ప్రాపర్టీ షల్ నాట్ బి టైడ్ ఫర్ టూ లాంగ్ ఎ టైమ్. ప్రాపర్టీ షల్ బి ట్రాన్స్ఫరబుల్ అట్లీస్ట్ అట్ వన్ పాయింట్ ఆఫ్ టైం. అది రూల్ అగైనెస్ట్ పర్పెచ్యుటీ. చెప్పాలంటే మనం చాలా కవర్ చేసినట్టు లెక్క. అంటే నెక్స్ట్ వీక్ కొంచెం తగ్గింది, మినిమైజ్ అయింది.
సార్ మీరు మైక్ ఆన్ చేయండి సార్.
ఏదండి?
జాన్ జోసెఫ్ సార్ ఇంటరాక్ట్ అవుదాం ట్రై చేస్తాను సార్. ప్లీజ్ సార్, అన్మ్యూట్ అయ్యి ఉన్నారు సార్, మాట్లాడండి.
జోసెఫ్ గారు చెప్పండి.
జోసెఫ్ గారు మీరు ఆడిబిలిటీ లేదు.
లేదు, నాది ఆడిబిలిటీ లేదా?
మీరు కదా సార్, ఆయన రావట్లేదు. జోసెఫ్ సార్ మీరు వినపడట్లేదు సార్.
సార్ జోసఫ్ గారు మీ వాయిస్ రావట్లేదు సార్, ఒకసారి మైక్ చెక్ చేసుకోండి సార్ జోసఫ్ గారు. అంటే మీది మైక్ అక్కడ మ్యూట్ అవ్వలేదు, మ్యూట్ అయ్యింది కానీ వాయిస్ రీచ్ అవ్వట్లేదు. అన్మ్యూట్ లో ఉన్నారు సార్, మైక్ ఇచ్చారు, సిస్టమ్ మైక్ మరి ఎందుకు రావట్లేదు.
చూద్దాం సార్, ఆయన మైక్ ఎందుకు రావట్లేదు.
సరే ఓకే, నెక్స్ట్ చూడండి సార్. సార్ రావట్లేదు సార్ మీది అసలు ఇన్స్ట్రుమెంట్ డివైస్.
గురుగారు నేను రాజారావు అండి.
చెప్పండి
మేడం గారికి చాలా తర్వాత ఇలాగా దీంట్లో పాల్గొని చాలా హ్యాపీగా ఉంది సార్. దీనివల్ల చాలా మందికి యూజ్ఫుల్ అవుతుంది సార్.
మిమ్మల్ని చూసి మాకు చాలా సంతోషంగా ఉంది.
క్లాస్ చదవబోయే మా అబ్బాయి ఫస్ట్ జాయిన్ అయ్యాడు కదా, తమ్ముడు గారి అబ్బాయి కూడా ఇప్పుడు మీ క్లాస్ విన్నాడు సార్ వేళ. ఇప్పుడేం చేయాలి, ఇప్పుడు జ్యుడిషియల్ ఎగ్జామ్ ప్రిపేర్ అయ్యే కూడా చాలా యూజ్ఫుల్ అవుతుంది సార్.
వెళ్తారండి మీరు డీజేకి
సార్? ఇప్పుడు కొత్తగా లా కంప్లీట్ చేసి మేజిస్ట్రేట్ సాధారణ వాళ్ళకి బాగా యూజ్ అవుతుందండి. మీరు అలాగే ప్రాక్టీస్ చేశారు కదా సార్, మమ్మల్ని ఎక్కడికి వెళ్ళినవారు కదా సార్ గురుగారు మీరు.
ఎక్కడికి వెళ్ళిపోయాం, మేము అందరూ ఇక్కడే ఉన్నాం కదా. అందరికి డిస్టెన్స్ తగ్గిపోయాయి కదా ఇప్పుడు. మరో అయితే రైలు ఎక్కాలి, బస్సు ఎక్కాలి, ఒక గంట ప్రయాణం చేయాలి, రోజు పట్టాలన్నది ఇప్పుడు అదేమీ లేదు కదా.
మేడం గారు చాలా హ్యాపీలు అవుతుంది సార్. రమణి శరత్ కూడా లైన్ లో ఉన్నారండి.
ఓహో వెరీ గుడ్, వెరీ గుడ్.
వాళ్ళు కూడా విన్నారండి క్లాస్, అది విన్నారండి మొత్తం.
చాలా సంతోషంగా ఉంది, అందుకే నేను కూర్చున్నాను.
లక్ష్మీ గురువు గారు మమ్మల్ని ఎప్పుడు ఆశీర్దిస్తూ ఉండాలి మీరు. ఓకే గురువు గారు.
సార్ నెక్స్ట్ క్వశ్చన్ ఎవరు చెప్పండి సార్.
జోసఫ్ సార్.
ఎస్
రావట్లేదు సార్, సారీ సార్, మీది వాయిస్ రావట్లేదు సార్.
సార్ నెక్స్ట్ పర్సన్ ఏసీసీ సత్యనారాయణ గారు చెప్పండి సార్. ఒకసారి సత్యనారాయణ గారు అన్మ్యూట్ చేయండి
సార్. ఫుల్ బ్లడ్, హాఫ్ బ్లడ్ అండ్ యూట్రన్ బ్లడ్ గురించి ఒక్కొక్కసారి ఏమన్నా ఎక్స్ప్లెయిన్ చేయగలరా?
రాలేదు సార్,
సబ్జెక్ట్ అది కాదు కదా.
సారీ సార్, లేట్ అవుతుంది.
అంటే సబ్జెక్ట్ ఇంకా ఉన్నారు సార్, అడిగే వాళ్ళు ఉన్నారు ఇంకా సబ్జెక్ట్.
ఏసీసీడీ
పివి శ్రీనివాసరావు గారు చెప్పండి.
నో ప్రాబ్లం సార్.
సో టుమారో హిందూ సక్సెషన్ యాక్ట్ ఉంది సార్, మీకు అక్కడ క్లాస్ కవర్ చేస్తారు సార్. ఓకే, అది హిందూ మ్యారేజ్ యాక్ట్, హిందూ లాస్ ఉన్నాయి రేపు. ఓకే
సార్, ఏసీసీడీ 39.
హలో
సార్ మాట్లాడండి సార్.
పివి శ్రీనివాస గారు వినిపిస్తుంది, మాట్లాడండి. మీ వాయిస్
హలో హలో
వినిపిస్తుంది సార్, మాట్లాడండి సబ్జెక్ట్.
చేసి మీ క్లాస్ చాలా బాగుంది, కొన్ని డౌట్స్ అన్ని కొంచెం క్లారిఫై చేయండి. నాగేశ్వర గారు నమస్తే అండి.
నమస్తే నమస్తే, చెప్పండి.
మరి చూడటం చాలా బాగా ఆనందంగా ఉంది, చాలా కాలం తర్వాత. ఈ మధ్యన రాలేదు కదా. ఉషా గారు మేడం గారిని కూడా అడుగుతున్నాను. గుడ్ ఈవినింగ్, ఇట్స్ వెరీ గుడ్ ఇంటరాక్షన్ అమంగ్ us. నమస్తే అండి ఉషా కిరణ్ గారు.
నమస్తే శ్రీనివాస్, ఎలా ఉన్నారు? చాలా సంతోషం. ఏంటి?
ఐఎమ్ వెరీ మచ్ హ్యాపీ అబౌట్ యువర్ ఇంటరాక్షన్ క్లాస్ అబౌట్ ది టీపీ యాక్ట్.
ఓకే, మాకు చాలా సంతోషంగా ఉంది మిమ్మల్ని అందరినీ కలవడం. రామారెడ్డి గారు, బీజేపీ గారు, సుబ్రహ్మణ్యం గారు వీడు అందరూ మనల్ని బాగా కలుపుతున్నారు. అందులో చాలా సంతోషంగా ఉంది ఆ విషయం.
సార్ విఎస్ఆర్ఎం సార్.
హలో
సార్ విఎస్ఆర్ఎం గారు మీకు అన్మ్యూట్ చేశాం సార్. అన్మ్యూట్ ప్లీజ్.
Yes, sir. Please, sir. Yes, sir.
No, I must thank you all for giving me this opportunity to hear Mr. Nageshwaraji like this. An enlightening topic he has taken, but a vast subject he has taken. Very vast.
Yes, sir. My three parents are Radhaswami.
ఇంతకంటే ఎలాగే ఉన్నా ఎలా మళ్ళీ మామూలుగా ఎలా అవ్వాలో తెలియక నాగేశ్వర్ నెక్స్ట్ టైం మళ్ళీ కంటిన్యూ చేస్తారు కదా. If there is anything we will discuss at that time, right?
Option is okay.
Thank you,
Okay,
sir.
thank you.
No hand raises, sir. So many.
జోసెఫ్ క్వశ్చన్ ఉంటే అడగండి, పోనీ అడిగి ఫోన్ లో అడిగి దెన్.
ఓకే సార్, అది బెస్ట్ సార్.
జోసెఫ్ గారు రాలేదే.
ఓకే
చెప్పండి వేసారు గారు. అంటే వాయిస్ మాకు రీచ్ అవ్వట్లేదు వేసారు గారిది. వాయిస్ అంటే కనిపిస్తున్నప్పుడు అడగాలి కదా, మనం రెస్పాండ్.
జోసెఫ్ గారు మీరు వాయిస్ అన్మ్యూట్ అయ్యారు సార్. మ్యూట్ లో అన్మ్యూట్ అయ్యారు సార్. మీరు మాట్లాడచ్చు సార్. ట్రై చేయండి.
మాట్లాడచ్చా
సార్? నమస్తే సార్, మాట్లాడండి సార్.
నమస్తే రామరెడ్డి గారు.
సార్ నమస్తే సార్, మాట్లాడండి.
నమస్తే నమస్తే, బాగున్నారా? మై కంగ్రాచులేషన్స్ టు యూ అండ్ ది గ్రేట్ కాకినాడ బార్ అసోసియేషన్. చాలా వండర్ఫుల్ లెక్చర్ మా బ్రదర్ నాగేశ్వరరావు గారు ఇచ్చారు.
థ్యాంక్ యూ రామారావు.
మీరు మోడల్ కపుల్, మీ మోడల్ కపుల్ ని మేము కంగ్రాచులేట్ చేస్తున్నాం వన్స్ అగైన్. అది చాలా మంచి సబ్జెక్టు. తర్వాత అది చాలా కష్టమైన సబ్జెక్టు, కానీ చాలా ఈజీగా దాన్ని మీరు చక్కగా ఎక్స్ప్లెయిన్ చేశారు అర్థమయ్యే రీతిలో. రియల్లీ యు ఆర్ డిజర్వింగ్ ఫర్ ది గ్రేట్ అప్రిషియేషన్. ఇది ఇలాగే కంటిన్యూ, ఇంకా ఇలాగే సక్సెస్ఫుల్ గా లీడ్ చేస్తూ ముందుకు పోవాలి. మీ జ్ఞానాన్ని 10 మందికి పంచడం అనేది చాలా గొప్ప విశేషం. అది ఆల్ ది బెస్ట్ సార్, ఆల్ ది బెస్ట్.
థ్యాంక్ యూ. కానీ మరి పెద్ద మాటలు మాట్లాడేస్తున్నారు మీరు.
రైట్, ఓకే, థ్యాంక్ యూ ఆల్. థ్యాంక్ యూ
సార్. థ్యాంక్ యూ సార్. సుబ్రహ్మణ్య గారు కంక్లూడ్.
థ్యాంక్ యూ సార్. వైఎన్ఆర్ గారు బీయింగ్ ఏ సీనియర్, మీరు అడిగినట్టునే మీరు ఇవాళ రావడం, మా సెషన్ తీసుకోవడం చాలా థ్యాంక్ యూ సార్. అలాగే కాకుండా మీరు ఫస్ట్ నుంచి ఈ ప్రోగ్రామ్ లో వెన్నంటే ఉండి మమ్మల్ని నడిపించారు. చాలా మంది స్పీకర్లు మాకు ఇంట్రడ్యూస్ చేశారు. ఈ ప్రోగ్రామ్ ని ఇంతవరకు ఇన్ని నెలలు కంటిన్యూ సక్సెస్ఫుల్ గా చేయడానికి కారణం మీరు కూడా, మా టీం మెంబర్. ఈ రోజు చాలా మంచి సబ్జెక్ట్ లా ఆఫ్ ప్రాపర్టీ మీద మీ ఎక్స్పీరియన్స్ తో మాకు అద్భుతమైన వివరణ ఇస్తూ మాకు చెప్పారు సార్. నెక్స్ట్ సెషన్ కూడా మీరు కంటిన్యూగా ఈ లా ఆఫ్ ప్రాపర్టీ ఫండమెంటల్ ప్రిన్సిపల్స్ కంటిన్యూ చేయాలని కోరుకుంటున్నాను సార్. ఈ రోజు చాలా మంది పార్టిసిపెంట్స్ యూట్యూబ్ లోను అలాగే దీంట్లో కూడా అటెండ్ అయ్యారు. థ్యాంక్స్ ఫర్ every participant. And the next session is also continued by YNR garu. Thank you sir, YNR garu, for attending this program sir. Thank you very much.
Most welcome sir, most welcome from our side.
Yes, sir.
థ్యాంక్ యూ. అవకాశాన్ని ఇచ్చిన మా బార్ అసోసియేషన్ కి, మా ప్రెసిడెంట్ గారికి, సెక్రటరీ గారికి, అలాగే మా బార్ కౌన్సిల్ మెంబర్ గారికి, మా బార్ లో ఉన్న ప్రతి మెంబర్ కి ప్రత్యేక ధన్యవాదాలు. పార్టిసిపేట్ చేసిన ప్యానల్ సభ్యులందరికీ కూడా ప్రత్యేక కృతజ్ఞతలు తెలియజేస్తున్నాను. సో మీటింగ్ కంక్లూడ్ చేస్తున్నాను సార్.